Hello, and welcome to a different kind of book launch. Thank you so much for joining us today. We are thrilled, those of us in the Transboundary Aquifer community, to celebrate the new book that has been written by Dr. Francesco Sindico called International Law and Transboundary Aquifers. It's a simple title for a very complicated subject. And to help us discuss this subject and to launch the book, we have a number of global experts with us whom we will be introducing as we go forward with the webinar. If you're joining us, then you probably are aware that we're going to address 3 different questions in a little bit. And we encourage you, those of you in the audience, to submit your own answers to the questions and also to pose your own questions. We won't be able to answer your questions in the 1 hour that we have, but we will be getting back to you. So please use the chat function as much as you want. It's there as a tool, and we look forward to hearing from you. Now, with no further ado, I'm going to ask Dr. Francesco Sindico to tell us a little bit about his book, what led him to write this book. And also, thanks a lot to Elger for publishing the book. Francesco, would you like to talk about the book for just a moment?
Thank you very much, Renee, and also to everybody who's joining us, both as speakers with me and as participants to this webinar. So 97% of available freshwater resources are found as groundwater. There are 272 transboundary aquifers, and only a handful have some sort of legal agreement or arrangement. And the international law of transboundary aquifers is in its infancy. These are the figures that actually draw my attention back in 2008, when I first started exploring the law of transboundary aquifers. Now, fast forward 13 years, we're in 2021, and we have 592 transboundary aquifers and groundwater bodies. We have a dozen or so between transboundary aquifer agreements or arrangements. And the international law of transboundary aquifers may not be in its infancy anymore, but one could argue whether it has really come of age in any serious way. Over these past 13 years, I have worked both in academia and in practice on the law of international transboundary aquifers. And the book that I am presenting today with my colleagues and friends is the result of this work. In this first part, in this first few minutes that Renee is giving me for presenting, I will just say a few things about the book, but then I will also share key moments and key people that I have met during my work. So, when working on a research project like this one, I always had in mind that I wanted to write something that would be of interest beyond what are sometimes too high walls of academia. I was thinking, why spend so much time on something if it only ends up in the hands of other researchers? So in order to write a book that could be of interest to policymakers and wider water-related stakeholders, I decided to start the book with a scenario. And the scenario contemplates 2 countries that have identified the presence of a transboundary aquifer and are keen to work together towards its management. So representatives from the 2 countries will ask themselves the following questions. First, are there any international legal rules out there that they should consider in the management of an aquifer? Second, are these legal rules legally binding, or should they just consider them as guidance? And third, are there examples out there of other transboundary aquifers where countries have used such rules for their management? Now, in the book, I answer these 3 questions, and during the conversation with the guest speakers with me, I will touch upon some of the points. I will discuss with them whether we should be talking about transboundary groundwater or transboundary aquifers. When it comes to management and international law, we will also discuss whether parts of international law of transboundary aquifers has crystallized into customary international law. And for both questions, we will ask ourselves, does it matter from a practical perspective? We will end the webinar discussing the future of international water law and the role of transboundary aquifer law therein. Now, before we dive into these questions, I do want to spend a little bit of time sharing with you some of the key moments and people that I met during my journey. My first encounter with this area of law was by focusing on the Guarani aquifer system. Thanks to a grant from the University of Surrey, I was able to travel, remember those days when you could travel? To three of the four Latin American countries that share the Guarani. In Sao Paulo in 2010, I first met Ricardo Hirata. Thanks to his insights, I not only got a better understanding of the science of the Guarani aquifer system, but also key management issues. In 2016, I had the pleasure of visiting once more the Guarani region, this time through a British Academy project, together with Seregas in Montevideo. Alberto Manganelli from Seregas and I led a group of 30 researchers from Uruguay and the UK to Salto, where we worked together on groundwater governance and learned more about the Salto Concordia border towns and their management of the Transboundary Aquifer. Going back to 2010, in August, I organized at the University of Surrey an international conference where I had the pleasure to first meet Gabriel Eckstein. Gabriel and I have since collaborated on many projects, both within and beyond academia. And every time I work with him, I learn something more about the law of transboundary aquifers and of law in general. At that same event in Surrey, I also had the pleasure to meet for the first time colleagues from UNESCO, Alice Aureli and Raya Marina Stefan. Over the past 10 years, I have worked very closely with Alice's team. I collaborated with the Groundwater Governance Project, the Greta Project, where I had the pleasure to collaborate on trainings in Southern Africa and Central America, where I worked closely with Stefano Burki and Marina Rubio. UNESCO organized the 2010 ISARM conference, where I met many colleagues, including Pilar Carolina Villar, with whom I then stayed in touch thanks to her expertise and interest in the management of the Guarani aquifer system. And we all look forward to the 2021 conference that will take place in December. So as we will discuss later, International Law of Transboundary Aquifers is also included in the United Nations Watercourses Convention. And one person who introduced me to the convention and to international water law has been Alistair Rio-Clark, who was at the UNESCO Water Centre in Dundee when I also was at the same university back in 2011, 2012. Another person who has been a great inspiration in international water law has been Salman Salman, who I had the pleasure to first meet on occasion of the 2015 IWRA Congress in Edinburgh. And it is my great pleasure to have both of them here with me today. Finally, I have been incredibly fortunate at the University of Strathclyde to have great people working with me on the law of transboundary aquifers. Around 2015, for some time, I had René Martin-Nagle and Stephanie Hawkins working on their respective PhDs, and Laura Movilla as a visiting researcher. We worked closely, we learned from each other, and we even had the chance of traveling together to Uruguay in 2016. And it is really great for me to have both René and Laura with me here today. There's so many other people who have contributed to the book, to my understanding of international water law and transboundary aquifers. I cannot mention all of them, but a really big shout to those who I see amongst the audience. Christina Fraser, Rosario Sanchez, Alfonso Rivera, Rosalind Malcolm, Shami Puri, Maria Carol, Karen Veloz, Maratignino, Todd Jarvis, and Christina Leb. Now, René has mentioned this already, but I want to stress that although there will not be any formal Q&A with the participants due to the time constraints, I am very keen to capture also your answers to the 3 questions that we will be discussing. Now, some of you have already done that, so thank you very, very much. But there's still time. You can send us the answers to Julie Gibson. She can put her email in the chat again. And we will capture them by the end of the week and share them with you next week. And if possible, we can also create a SCELG publication, a SCELG dialogue with the input from all of you. But for now, sit back, relax, and enjoy the rest of the webinar. Do use the chat, as I see you are doing, to introduce yourselves. It's always nice to see who's in the room. And if you do have some questions, use the Q&A function more than the chat if it is a question. And although we will not answer them, I will take a note of them and I will do my best to get back to you by the end of the week. I give the floor now to René, and I'm very excited to start the conversation with my colleagues.
Thank you, Francesco. I'm excited too to hear what everyone has to say. So let's start with the first question, which you see on your screen. And there is some debate about whether we should talk about transboundary groundwater or transboundary aquifers. Is there a difference, and does it matter? We'll start with Ricardo Hirata, who is from the University of Sao Paulo. Ricardo, will you take the floor, please?
Oh, hi. First of all, congratulations for the book. That's a really good contribution for this big debate, big aquifers, big debate. Okay, at first I thought that the question could have more semantic than practical implications, but getting a little out of my geological pragmatism, I see that the discussion is relevant, and I look forward to hear from my fellow lawyers. I understand that an aquifer is a groundwater body, a unit with a specific volume and limit in space. And it's characterized by being a geological unit in its stratigraphic concept. The fact that it has a specific extent, a volume, the limits facilitates establishing agreements and the treaties. The water flows through some physical medium. For example, in the Guarani Aquifer project, which I participate as a member of the World Bank, people define an operative Guarani, one that could be recognized in the 4 countries. On the other hand, transboundary water is more associated with water resource. It is a dynamic concept and incorporates the water movement. In this regard, we are managing the water, not the aquifer itself, that is rock. So for me, from a hydrogeological point of view, the term transboundary water would make more sense, mainly because water can pass through different geological formation and therefore different aquifers. But I'd like to raise 2 points about the transboundary water, which has implications for this terminology too. In hydrogeology, the impact caused by anthropogenic activities such as a landfill industrial facility extends over a few hundred meters and very rarely will be greater than 2 kilometers, except, for example, in karst systems. In intense exploitation, the impacts may be more significant, but they are also restricting space. Thus, the problem occur very close to the borders, country's borders, and will not extend across the entire aquifer. It means we are speaking about the water flowing at the border and not in the entire aquifer. Therefore, the concept of transboundary water makes more sense. The second aspect is the lesson that we learned from the Guarani project here in South America. The most striking cross-border aspect for me was people from different countries working together and sharing ideas and data. This was the most vital cross-border aspect of the Guarani project for me.
Thank you, Ricardo.
Thank you.
And now I'm going to ask Gabriel Eckstein to give us his thoughts on this question. Gabriel is a professor with Texas A&M University, and he's also the president of the International Water Resources Association. Gabriel?
Thank you, Renee, and thank you, Francesco, and congratulations on this wonderful, wonderful book. I want to build on what Ricardo was discussing about the differences between groundwater and aquifer. And I will say that we won't resolve which one we should be using, but I think it's really critical to understand that there is a difference. And in fact, this community needs to have a better sense of what we want to regulate, because I'm going to give you a lawyer's perspective. The idea is, we are trying to manage and regulate and conserve something, but what is the thing that we want to focus on? Is it the groundwater, which is the water that's flowing through the matrix, through the formations, or is it the matrix, the container of the groundwater? And from a legal point of view, this is really significant because the mechanisms that you use to regulate the formations could be very, very different than the mechanisms that you use to regulate the water that is flowing through the formation. So this is something that you have to take into account when you are writing agreements, treaties, MOUs, or any kind of arrangements with, between neighboring countries. Now, you have to think about what are the implications of one over the other. Well, if we're talking about an aquifer, for example, well, what is an aquifer? You're talking about the formation. Well, where does the formation begin and where does it end? So we're talking about geographic scope. Do we include the recharge zone and the discharge zone? Is that part of the aquifer, or is that outside the definition of an aquifer? And if you think about it, these are really important areas in terms of the water coming into the aquifer, and they could contaminate the aquifer, or you can capture water before it reaches the aquifer. And depending on where the recharge zone is in relation to the storage, it could be in one country versus another country. What is this what you want to regulate? And this is something that is really critical to think about. On the other hand, if you want to regulate the groundwater, the water itself, well, what is groundwater? Is it the water in the saturated zone? What about the water in the unsaturated zone? What about the water that's falling on the recharge zone? What exactly do you want to regulate? And I will tell you that I had the honor to work with the International Law Commission to try to come up with these kinds of definitions. And it was exceedingly difficult to come up with a legal definition for things like groundwater and aquifer. And this is something that I think our community really, really needs to take a closer look at and try to come up with some ideas so that we can then work with regulators and international lawyers and governments to figure out how to regulate transboundary groundwater and aquifers.
Thank you, Gabriel. Francesco, do you have some responses to what Ricardo and Gabriel had to say?
Yes, absolutely. So thanks to both of you for your comments, and I'd love to have a bit of a conversation before we move on to the second question. I think this is the part where both in the book and throughout my work on transboundary aquifers, I struggled the most. I think I'm not the only international lawyer that got almost scared when we first heard what an aquifer was, how recharge worked, how discharge, how this and that. I mean, I've never been a very strong scientific person, I'll be brutally honest. And so having people like Ricardo and Gabriel around me has always, has built my confidence, but I'm still a bit shaky, I'll be honest. I deal with the science to some extent, if you want, in in my second chapter of the book. And I'll say a few things here. One, what do we want to regulate? Is it the groundwater? Is it the matrix? I think that is incredibly important, but at the same time, it's also important to understand what groundwater is important for and where it can suffer going forward. And I'm thinking of the pressures from climate change, for example. I'm thinking of the relevance of groundwater governance, if you want to call it more generally, to sustainability, to the Sustainable Development Goals. Now, that may not have an impact on the definition on the one versus the other, but I do think it just shows the complexity and the fact that this hidden natural resource is so important. Two other comments. We have global regulation, the ILC efforts, for example, that Gabriel mentioned. But we also have regional regulations, so the Guarani Aquifer Agreement that Ricardo introduced me to and so forth, but also very local, very village almost focused management. I remember Ricardo talking to me and other colleagues in the Guarani about management precisely in specific villages near Sao Paulo and so forth. I do wonder whether, and this is really the point I want to make, which I think is important, and it's about future implementation. So when we look at the future implementation of, be it the Guarani Aquifer Agreement, or how the ILC draft articles may provide guidance to future agreements, it's really in the negotiation of these regional, bilateral, or even local management measures that the definition of groundwater vis-a-vis aquifers will become very important. And for example, Ricardo mentioned all of this matters, but if you have a karst aquifer, it's a completely different picture. So one would think, well, law cannot be so blind not to see that karst aquifers work in a different way than other aquifers. So to a long story short, and then I'll be happy to get some reaction from Gabriel and Ricardo. I do think that lawyers and negotiators have to be humble enough to really stop and try their best to understand what the science is telling us, and then adapt the regulation, the law, and the management to what a specific aquifer is and the specific pressures. And I don't know, Gabriel, Ricardo, if there's anything here that you would like to add or comment on based on your own experience as well.
Ricardo, do you have a?
No, you can start.
Yeah. So let me just maybe add one thing which sort of builds on what you just said, Francesco. Because we don't yet have a firm direction in terms of what we should be regulating, and because this is so complex, and maybe most importantly, because it is so different. You mentioned karst aquifer, there's sandstone aquifers, there's shale aquifers, there's the Guarani aquifer, which is different from the Nubian sandstone, which is different from Northwestern Sahara, and we need local approaches. I think, at least now, I'm not sure we can come up with a universal rules for everything. I think that we really need to look at locally and have the local participants involved in sort of developing what might work for them. We are at a very, very early stage of the development of what I might call international groundwater law. It hasn't yet developed, and we need experiences and practices and opportunities to even test some of these ideas. Water is very personal, and so local approaches, I think, are really critical to try to figure out, well, what is the best way to regulate under what circumstances?
Yeah, I totally agree, Gabriel. And following the idea of the Francesco and my answer of the question, that I said that problems in groundwater generally occurs very locally, and actually people has to work locally because affect just the community or just that region, that specific region. Although it's a big aquifer like Guarani, and in the Guarani particularly, we don't have many conflicts on the border, but still it's something that affects just a few kilometers from the source. And because of the characteristic of the aquifer, it means that it can be extracted using individual and sometimes private wells. For example, in South America, normally 80% of the total extraction of groundwater comes from private wells. It means that the people has to be involved in this process, and that the people is involved locally, not in a huge aquifer, but just because the participation has to be local at the watershed level, or also in the municipality or in communities. That is really, really important. It means that it is very challenging because we are speaking about the international laws, treaties, etc. But actually you have to see exactly what happened on the border or exactly on that specific community. That's really, really important. And it's totally different from a river or a big lake.
I think this is one of the last things I would like to comment. What just Ricardo said, it's very different to a river or a big lake. While there are also some similarities, I do think this is one of the things I have learned over the years. And again, thinking of some practical examples of political cooperation, there needs to be that training for policymakers and stakeholders that we are talking of two different natural resources. Some elements are not that dissimilar, but just for example, concepts as downstream, upstream, sometimes do not operate in the same way. We have a 3D dimension and water tables here and there. And it's really something that is incredibly, incredibly complex. 30 seconds, and then we'll move to the second question. I think the idea of hotspots and pilot projects like in the Guarani project And really those areas on the border that suffer more pressure is something that really deserves more attention going forward, also from a policy perspective. So would like to thank Gabriel and Ricardo, and I'll give the floor back to Renee.
Thank you. And looking at what's going on in the chat, this topic and the book launch webinar in general are really initiating some very interesting questions and dialogue. So thank you to those of you who are voicing your opinions and thoughts in the chat. The second set of questions that we're going to address, as you see on the screen, is there any aspect of the international law of transboundary aquifers that is crystallizing as a customary international law? And does that really matter? To answer this question, we're going to start with Laura Movilla, who is with the University of Vigo. Laura?
Yeah, hello. Hello, everybody. Thank you, Renee. Of course, congratulations, Francesco, for the book. As for the first question regarding customary international law, we all know that the legal regime of transboundary aquifers is much less developed than the regulation of transboundary surface water. For instance, the draft articles on the law of transboundary aquifers of the International Law Commission is formally not legally binding instrument, but it contains substantive and procedural rules that some of them may be considered customary law in relation to surface water. But I think there's consensus that when these draft articles were adopted in 2008, they contained mainly progressive development of international law in relation to transboundary aquifers management, because mainly there was almost no state practice. And in fact, even today, state practice is still quite scarce and heterogeneous, although growing, that's true. For instance, as Francesco mentioned, we still have a very small number of specific agreements or arrangements on transboundary aquifers. But if we look at the normative content of these few agreements and arrangements, we also compare it with the normative content of the draft articles or other international legal instruments like the UNEC model provisions on groundwater. One of the few features that I see that they have in common is the establishment of some kind of joint mechanism for the exchange of data and information. So I think we can probably consider that this exchange of data and information and the establishment of joint mechanism for cooperation, we can consider them at least emerging international customary law, probably. And there are another procedural obligations, such as the notification of plan measures or the obligation to undertake an environmental impact assessment, that are also gaining presence in this kind of legal instruments. So maybe they are also crystallizing as international customary law in this field. I think we need to have more practice, more legal instruments to really know this for sure, but probably they are crystallizing. And I think it's something very important because, as we know, especially lawyers, general international customary law is binding for states unless they have persistently objected to these rules during its formation. So it has a lot of power. They have the power of transforming the normative content of soft law instruments, such as the draft articles, into enforceable legal obligations. So it really matters if we can consider those rules customary law or not. Also, as I see it, when we have customary law in a specific field, I think it shows a kind of maturity of that legal regime, some consensus about that legal regime globally. So if this is true, if these rules are crystallizing, I think that's also a proof, it's showing a growing maturity, let's say, of the international law of transboundary aquifers. So I really think it's a very important topic and not an easy one. it's a very important topic that of try to identify that emerging international customary law.
Thank you, Laura. And next we're going to hear from Pilar Carolina Villar, who is with the Universidad Federal de Sao Paulo. And I should have mentioned early on that the bios for all of our speakers are in the chat, and you'll see them coming from Julie Gibson. So feel free to check out the bios too. Pilar?
Hi, everybody. I would like to say thanks for the opportunity and congratulate Francesco for this great book. Concerning the question proposed, I'd like to put emphasis that we have two global treaties for water, which are the UN Water Course Convention that includes part of groundwaters, but not aquifers, and the pan-regional UNECE Water Convention, whose scope is transbound water, no matter if they are groundwater or surface water. Both instruments have entered into force, but they are far away from being globally accepted by countries. For example, in South America, no of the South America countries has joined these instruments. So for many countries, the substantive and procedural obligations established by those instruments are considered part of customary international water law. On the other hand, we have the draft articles on the law of transboundary aquifers that represent the main step to the codification of customary international law applicable specifically to the case of transboundary aquifers. So, groundwater international law is better developed since it is included in the scope of these two global treaties and other customary international law initiatives like the Helsinki Rules. So, in my perspective, most of customary international water law obligations should be applicable to groundwater. In the case of aquifers, our main instrument is the draft articles. So I really don't see that we can say there is a consolidated consensus in the practice of states. However, this instrument calls the attention to the applicability of international water obligations to aquifers and highlights a very consolidated customary duty, which is the obligation not to cause significant harm, which makes possible to strengthen another obligation very important to aquifers, that is to carry out environmental impact studies. For me, these two obligations are central in the case of aquifers that include the geological formation under the sovereignty of states. So why this matters? Despite the fact that many states don't join the two global water conventions or the difficulty to transform the draft articles in a binding instrument, the consolidation of certain obligations as a customary international water law may help states to embrace those principles and norms in bilateral or regional aquifer agreements, which would increase the number of cooperation initiatives over aquifers. Also, the discussion of these principles and norms can stimulate countries to establish better national policies or other cooperative actions not necessarily conducted by international actors. And that's it. I hope I get the time.
You were perfect, actually. Thank you. Francesco, would you like to respond to what Laura and Pilar said?
Absolutely. Thank you so much, Pilar and Laura, for joining me. On a side note, Laura was the last person I met before the pandemic started in a work environment outside of Scotland. The two of us were for a project in Barcelona, and I was doing the finishing touches to the book, and Laura was incredibly useful. So yeah, hopefully we'll see each other very soon.
Hope so.
4 quick points to that. I mean, obviously, once I got over the science and had the headaches of trying to understand it, I then landed on international law, which obviously felt like a much more soft landing for me. I felt much more familiar to the topic. And in the book, I answer this question very much through the work I have in chapters 3, 4, and 5 in particular, where I touch upon many of the points that Pilar and Laura mentioned, the various instruments, not just the draft articles, rightly said, also the Water Courses Convention, the Water Convention, the model provisions, and what they say, but also the key question, do they amount to customary international law? But the first point is, I want to answer the why does it matter? Because that to me really is important. If customary international law is just a theoretical question, to be honest, I'm not that interested. But let me take you back to the practical scenario. Let's assume that we do have two countries that have political will. That's a huge assumption, but let's assume that's the case. And as Pilar said, let's assume we're in a region where they are not parties to the treaties that give you some indication. Once they understand that customary international law is applicable to all members of the international community, then almost suddenly, some could say almost magically, you realize, oh my, if we can assert that this specific conduct of a state, either an obligation or a right, amounts to customary international law, I actually have to abide by it. I have to do it. Now, that doesn't mean that the state may not breach it. Just like if there's a red light in a street, especially as an Italian, I may not really look at it in a very red way. I never do that. But the point is, just because there may be a breach, that doesn't mean it's a law. So it has a huge practical relevance when it comes to negotiating an agreement, or in a case of a dispute, for example, when it actually comes to resolving a dispute. Now, which of the provisions are customary international law? I would very much agree with what Laura said. The obligation to cooperate, let's say, and the procedural provisions that underpin that obligation, so exchange of data, monitoring, and even the developing of joint mechanism to some extent, I think that even in the field of transboundary aquifer are amounting to customary international law. When it comes to no harm, I definitely think that this applies to all international law, hence also to transboundary aquifers. The EIA, as Pilar mentioned, is again part and parcel of that to some extent. Where it gets a little bit more complicated, I think, is with the obligation of equitable and reasonable utilization, which I think at transboundary surface water level, I would say it has a strong record, state practice and everything. There are difficulties on saying exactly what it means. I don't think we should get trapped in that question. I think it's very contextual and it will depend on the facts. But when it comes to transboundary aquifers, as I discuss in the book, that is a bit more complicated. I do think it's emerging, but we may not be there yet. Now, the last thing I would say is that Laura said more practice is needed. And I think this is to some extent, almost the conclusion of my book. You know, it's too soon to say. But if more practice is needed, I think key questions, both from lawyers and policy and people interested in policy with transboundary aquifers, and I see so many of you in the chat, is questions as, okay, how can more practice even happen? What needs to happen to have more practice? Especially when we may not even yet know where the transboundary aquifer is, the exact delimitation. When we may not even very well know what the transboundary aquifer, the relationship with the economics, with the social aspects on top, and where to start. And this is where I think the scenario and understanding what law is there and what starting point from a regulation perspective becomes relevant. So I talked maybe a little bit too much, but I do want to give Pilar and Laura just a chance to maybe react to one comment or bring in your regional perspective or your own experience. I'll start with Pilar this time, and then I'll give the floor to Laura as well.
Well, I think at this point, the more need of practice is a key point. Well, I came from the case of Guarani, so I have to mention something about the Guarani. Well, we have the Guarani, we have the agreement entered into force, but for example, Brazil didn't publicate the act saying the agreement enter into force. So what's going on with the cooperation? And then I think a point that Hirata and Gabriel mentioned before, the thing of the local. Guarani, it's a too big aquifer with very different and the difficult to consolidate now an international agreement. So we managed to make the international agreement, but we cannot make this international agreement to work in practice. So that's another challenge that we put also in the equation. The challenge to make the agreement and now the challenge of make this agreement reality. So that's one point. Another point is this thing that I think that takes the question of groundwater and aquifers. In the end, groundwater is the thing that has to be regulated in this customary international law or in treaties. The idea of the aquifer is the idea to make a geographical basis of this groundwater that's shared by two countries. Because you don't have to make an agreement to all the Guarani. You just have to make an agreement to the portions of the Guarani that are shared. And another point that is important is that international scale has to work with national scale, because to have international agreements, you have to know aquifers, or at least the desire to know aquifers, to promote cooperation between the states, to have knowledge to make any kind of resolution on that aquifer, and also to monitor this aquifer. That are the beginning of any kind of cooperation, and the beginning to have the basic information to sit in the table and get this more strong cooperation and more strong commitments in relation to this aquifer.
I'll ask Laura to just very briefly, and then Renee can have the floor again.
Thank you, Francisco. I just wanted to point out what I think is another challenge that, and I think it's just to try to explain what customary law is to non-lawyers, because I think it's one of the most difficult things to understand regarding the sources of international law, and because there are binding rules at the end, even if they are not written anywhere, or even if the states involved have not ratified, as Pilar said, any treaty that contains them, and so forth. So I think that's the idea itself of what customary law means. It's a challenge itself.
Absolutely. Renee, I give you the floor.
Right. Very interesting discussion about customary law. And now we're going to look at the future. We're going to start with Alistair Root Clark, who is with Northumbria University. Alistair, would you please give us your thoughts on what you think international law will evolve to, particularly with respect to the international law of transboundary aquifers? Alistair, you may be muted. Always a hazard with Zoom, right?
There's always someone. Yeah, thanks very much. Thanks for the invitation. Congratulations. Let me add my congratulations, Francesco, for the book, which is really great to see. Yeah, I mean, you're asking an optimist, which is maybe a bad choice for this session. But what I would say, when I think about a 10-year time frame, I think about SDGs. And I think of our target. We have a target 6.5 to achieve IWRA at all levels by 2030. And more specifically within that, we have this indicator on 652, which is looking at the coverage of operational arrangements across all river and lake basins, all transboundary aquifers. Pretty ambitious, to say the least. But I think that's already an amazing step forward. But we actually have a global system now that monitors progress on the development of these arrangements. And we've also had great buy-in from countries. I mean, over 80% of countries sharing transboundary waters have submitted national reports on the current status of their basins, their aquifers, and whether they're covered by operational arrangements. But despite that great engagement, there's clearly big challenges. And I think when we look at transboundary groundwater, the first stuff, the reports are saying not enough data, and data is a big issue. Preventing countries from reporting on their transboundary groundwaters, which is a useful finding in itself, but it's certainly something that needs to be addressed. Even when there's global data sets are available, there's still sometimes a reluctance to countries to use that data and to report that officially. So some data is a big challenge. And also we see from the second reporting, which is just finished and we're working on the analysis, that there's only about 44 countries that are pretty much on track to ensure that all their river, lake basins, aquifers are covered by operational arrangements. So a huge acceleration is needed to cover that. But we also see encouraging signs. You see a lot of countries reporting and using things like groundwater working groups or task force within river basin, which is largely a river basin arrangement, to at least start looking at groundwater issues. And I think there's a Stampery Aquifer mechanism under Orasicom where you see that as a model. River basins, and as we know, river basins aquifers are not a perfect match, so that doesn't always work, but I think that's an interesting trend. So I think just in the interest of time and just summing up, I would say I'm quite positive that we're getting better at monitoring, trying to find the gaps, trying to address these data challenges, zooming on where really precisely where the support might be needed. So I think at least we'll have that in the next 10 years, but I would hope we'd have a good step change in the number of river, lakes and aquifers covered by operational arrangements. Thanks.
Thank you, Alistair. And now we're going to ask Salman to give us his thoughts. I would like to say that Salman was formerly with the World Bank, head of the Water Law Division, and I consider him to be the godfather of groundwater law. He's also been a personal mentor of mine for more than 10 years. So Salman, it's a pleasure to introduce you.
Thank you very much, Renee, and congratulations, Francesco, again on the publication of your book. I was asked by Edward Elgar some months back to write the endorsement for the book. So I had to read it carefully, and I did read it carefully, and I wrote the endorsement. I don't know whether they included it or not, but
Salman, can I interrupt you for a second?
Yes.
We cannot see you. Could you turn on your camera, please? There we go.
Okay, sorry, I thought I clicked on that. So the question is the directions in which international water law is moving, and what about the transboundary aquifer? Whether this will play any role in the evolution of international water law. That's a very, very wide question. I think it has already been addressed one way or another by Francesco, Ricardo, Laura, and also by Alistair. And I will add my hands-on experience as a former World Bank advisor on water law, which I started working on in 1994. The World Bank policy for projects on international waterways is a surface water policy, as it is written. So when I took over, and it has already been there for a long time, and it has always been dealing with surface water. We faced the challenge of groundwater in one project in Northwestern Sahara Aquifer. And when we told them, look, the policy applies, they said, oh, no, it doesn't apply. Where is that in the policy? The policy is about surface water. The country involved said no, the staff said no, management of the bank said no. And I insisted, I said yes. And the issue became very difficult. I said, look, the same issues, the same policies, the same perspective that we have for shared surface water do apply to shared groundwater. It was a very challenging, it delayed the process of the project, committees were formed and one after the other. And finally, the General Council intervened and said, yes, the rules of international water law apply, whether it's groundwater or surface water. And I think that was a major development, because the World Bank policy for Project International Waterways, which I happen to have written a book about, for those of you who haven't seen the book, and its evolution and its content has contributed largely, has major contribution to international water law and to its evolution, because the World Bank has a large program of lending for projects in international waterways, and there has always issues would come when it's a shared river or lake and later on groundwater. So that wealth of information has really contributed a lot to the evolution of international water law. I remember having meetings after meetings with the ILC rapporteurs in 1994, just at the time when the UN Convention was being introduced to the Sixth Committee and on the way to the General Assembly. So I would say that, judging from my experience, there was a gradual process, but steady, for recognition of shared groundwater as a source that's where international law would be applicable. And now, although the policy of the bank has not been amended, I hope Christina Levy is here to brief us on any developments. But although the policy has not been amended to make an explicit reference to groundwater, to shared groundwater, the application of shared groundwater is widely accepted. There is nobody challenges it, and I think that just shows that the evolution is in the direction of cooperation, which I keep saying, and I'm not the first one, I'm not the only one to say that it is a pillar of international water law, cooperation. And I see that cooperation in a number of ways, in a number of aquifers. We look at the Nubian sandstone, where the memorandum of understanding was signed. We have before that the Genovese aquifer. We have the DC. We have the Guarani, which I'm humble to say that I contributed to the meetings that were held in the World Bank when the understanding were that the aquifer was really, each country at the beginning said it's a local aquifer and may not really have connections to the part of the aquifer in other countries, but gradually and with the studies, it was realized and agreed that it is a shared aquifer. So my points is that we are moving in the direction of cooperation and in the evolution of more principles of international water law. Thanks.
Thank you, Solomon. Yeah, forgive me for interrupting, but in the interest of time.
Okay.
All right, Francesco, would you like to respond to what Alistair and Solomon had to say?
Yeah, so thank you so much, Alistair and Solomon. I am the first one to feel sorry not to give you more time. Obviously, we could spend a lot of time discussing these issues, and I'm sure that the participants feel the same. So I gave you, obviously, I mean, all questions were tough, but to some extent, the crystal ball exercise is always the toughest, although you can go in whatever direction to some extent. So let me also attempt to give you my crystal ball. So, and I'll try to be also optimistic, Alistair. So here we are in 2030. There has been only one pandemic. We are all traveling again. We're all, embracing ourselves and so forth. And there are four things that have happened in 2030. The first is that in a potential second edition of the book, rather than having only 17 transboundary aquifer agreements discussed in the last chapter, chapter 6, we have a bit more. So there is more practice. But more importantly, a lot of these agreements and arrangements are not just paper tigers. They have funding. They acquire and develop more knowledge about the transboundary waters, and in particular the aquifers in this case. And through this increasing cooperation, even civil society and policymakers understand the importance of groundwater, transboundary aquifers, and their connection with surface water. More things happen in 2030. In 2030, not only do we have all countries reporting to the SDG 5.2 and the Sustainable Development Goals, SDG 6 is on track, or if not almost on track, definitely going in the right direction. The SDGs, although soft law, have provided that normative direction, which is very much what soft law and goals do. You can't ask too much to them, but already that trajectory is quite something. But there's something else. Finally, the transboundary aquifer community has been able to crack the climate change community. And climate change adaptation policymakers, climate change adaptation community has finally realized the importance of groundwater governance and are starting to get interested in international water law, and in particular also the international law of transboundary aquifers. And this is a hugely important achievement that colleagues, even in the chat, participants, and those of us here as speakers, are working hard towards, bringing the climate change and the international water law community closer together. A third thing that happens in 2030 is precisely this, bringing more data, having even more data. And in the Guarani region, which I also had the pleasure, as I said at the beginning, to learn about, to visit, to be in touch with a lot of people working in the Guarani. The Guarani Aquifer Commission has been implemented, has been established in the SCELG Plata. But again, it's been done in a way, and in 2030 it works with a combination of technical expertise, political expertise, legal expertise, so that it actually matters. And it's not just another commission without funding, without too much relevance, obscure, untransparent. In 2030, the implementation, especially the focused project-specific implementation on the border at the pilot scale, will be done also thanks to the implementation of the SIC Plata Commission of the Guarani Aquifer. And the last thing, in 2030, international water lawyers and those of us who also specifically focus on transboundary aquifers start to have a conversation, not just between academics, but also again with policymakers and wider stakeholders, to understand that it's not just about climate change. Water affects so many other areas. For example, international investment law and the big infrastructure projects that also Salman was mentioning. No, they are not regulated only by international water law. There's so many other areas of international law and customary international law therein that become relevant. By 2030, we will have been over the complexity, the headaches of trying to understand, and we're actually going beyond the academic discourse and trying to have policy relevant discussions with people interested in water, but also bringing in people from other disciplines. So this is my vision for 2030 for international water law. And I briefly ask Alistair and Salman if they have any further very quick point, because we are getting close to the end, that they want to add before I finish up the webinar. So I'll ask Salman to start this time, and then Alistair, just very brief reactions if you want.
I mean, despite the fact that we have some problems, some acute disputes in some of the major shared water courses like the Nile and some others, but I think the trend generally, in my view, as someone who has been watching it for the last 25 years, is that it is a trend towards cooperation. And this cooperation has taken the shape of agreements, memorandum of understanding, whatever instruments. And in other cases, it has just taken the shape of without an agreement, representatives of countries sitting together and working together and exchanging information without formalizing it. Maybe they're testing the grounds. And this has happened, for example, with the Guarani Aquifer before signing the memorandum of understanding, even with the DC also, before signing the memorandum of understanding and Ruby and Sandstone. So I tend to agree with you, and I tend to say that I am quite optimistic that we are moving in the course that international law is about. It's about cooperation, and I think I do believe that we are moving in that direction.
Yeah, I would just quickly add, I think the momentum is in the right place. We're getting more. I mean, since the last reporting on SDGs, we've got 20 more arrangements are now in operation. We're getting more and more. We're understanding data gaps. We're trying to address those. So I think, you know, the optimistic note is that we are moving in the right direction. Hopefully, that can accelerate.
So I will take the opportunity to just say a few last words before I give the floor to René, just to conclude formally the webinar. It's already 3 o'clock to my watch, so I will keep it very, very brief. First of all, I really, really want to thank not just those colleagues and friends who have joined me as speakers, let's say in the webinar, but also those who have attended as participants. A lot of you I know. Those who I don't know, I hope to get to know you via email, by sending us your answers to the questions that we have discussed. I repeat, there is still time to add your name to those who have already answered. And again, thank you so much for providing us some feed for thought also for this webinar. And by sending an email to Julie, and Julie has sent her email in the chat. You just send us your answers, keep it brief to some extent if you can, and we will try to share them to all of you via email next week, and then see if we can format it in a slightly nicer way. I personally have enjoyed this tremendously. I look forward to having, be it IWRA, World Water Congress, World Water Forum, or ISARM 2021, some formal event where we can all get together. But I will finish by saying that when I wrote this book, I really wanted to do something that could be read, not just by lawyers and by researchers. And I hope that at least one person amongst the participants who may not be a lawyer feels not scared from an international law book and will want to either get a copy of the book or find a copy in whatever way and enter into a discussion with lawyers, because we do not all bite. Some of us do, but we don't. And we also have we all have skill. We also have skills. We also have an expertise which is necessary in the big old puzzle of global water governance, and also when it comes to transboundary aquifers. So I will leave it there. A big thanks to René for chairing this. A big thanks for Julie for helping behind the scenes. And I will leave the floor to René, and I will continue the discussion via email with anybody who wants to ask any further questions afterwards. Thanks, René.
Oh, it's truly been my pleasure to participate in this fascinating discussion. And I think all of us feel that this could go on for a lot longer. And maybe that's an opportunity for SCELG, to host a webinar based on groundwater law. So I just leave that idea with you. Thanks to all of you for joining us. And once again, thanks to Edward Elgar for making this webinar possible. As you may have seen in the chat, you get a 30% discount on the price of the book just by participating in this webinar. So go to the Edward Elgar website and look for the book and buy your very own copy. I'm sure Francesco would be happy to autograph it for you. I think that's it. We'll close out, and thanks again to everyone. And I hope to see you somewhere in the world, even if it's just on a screen someplace. Take care. Bye-bye.
Thanks, René.
Thank you very much. I'll just leave the slide for a minute and then I'll close the webinar. If anybody wants to add anything else in the chat.